Attention, please, while the Honorable Chief Justice of the Philippines and the Associate Justices of the Supreme Court of the Philippines are now entering the virtual session hall. Hear ye, hear ye, hear ye, all persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Call the petitions.
Your Honors, good afternoon. This is a continuation of the oral arguments on the 37 consolidated petitions assailing the constitutionality of Republic Act No. 11479 or the Anti-Terrorism Act of 2020.
Appearances.
Good afternoon,
We would like to request the appearances of the 7 presenting counsels for the petitioners and the counsel for the respondents.
Yes, good afternoon, Your Honors. Attorney Howard Calleja for GR number 252578, Calleja et al. Versus Executive Secretary et al. Ready, Your Honor.
Good afternoon, Your Honors. Edsel Lagman, same appearance in GR number 252579. We are ready, Your Honors.
Good afternoon, Your Honors. May it please the Court. The Free Legal Assistance Group, represented by Attorney Theodore Te, Attorney Michael De Castro, Attorney Camille Ross Parpan, for the petitioners in GR number 252741. Ready, Your Honor. Thank you.
Good afternoon, Your Honor. Attorney Darwin Angeles, same appearance for petitioners in GR number 252736. We are ready, Your Honor.
Attorney Ursua.
Good afternoon, Your Honors. Respectfully appearing for the petitioners in GR number 252747.
Your Honors, good afternoon. Assalamualaikum. I'm Attorney Bantuas Lukman. Together with me, Attorney Musa Malayang, respectfully appearing as counsel in GR number 252759. Thank you.
Good afternoon, Your Honors. Attorney Randall Tabayoyong, respectfully appearing as counsel for the petitioners, Integrated Bar of the Philippines and its Board of Governors in GR number 253124.
For the respondents.
Good afternoon, Your Honors, and may it please this Court. The appearances for the respondents are the following. Assistant Solicitor General Marisa de la Cruz Galandines, Assistant Solicitor General Raymond Rigodon, Assistant Solicitor General Rex Bernardo Pascual, Assistant Solicitor General Bernard Hernandez, Assistant Solicitor General Diana Castañeda de Vera, State Solicitor Eduardo Poquis, and Associate Solicitor Dominic Clavano. We are ready, Your Honors.
Okay. We recognize the presence of the Amici Cray, retired Chief Justice Reynata Espuno, and retired Justice Francis H. Hardilesa. Good afternoon. Before we proceed with the interpellation of Senior Associate Justice Bernabe, we will allow Justice Marvick Lonen to propound additional interpellation questions to the respondent. Justice Lonen, please proceed.
Thank you, Mr. Chief Justice. May I ask whoever is in charge, again with freedom of expression, to take the podium?
Good afternoon, Your Honor.
Good afternoon, Eid Mubarak. How long have you been a Solicitor General?
Assistant Solicitor General, Your Honor, since 2015.
So having dealt with cases that have reached the Supreme Court, you realize that every case is an opportunity for us to revisit our doctrinal interpretation of many issues. You agree?
Yes, Your Honor.
And for us to be able to either strengthen our promulgation or pronouncement of doctrinal issues and make it into something which is more canonical, we sometimes require not only that the jurisprudence in your memoranda is not only repeated, but also that its philosophy or its rationale is fully explained. You agree?
Yes, Your Honor.
Therefore, for there to be a very robust discussion in your memoranda, perhaps you should not only be concerned about the progeny, meaning to say the genealogy of cases that that have repeated a certain doctrine, but also likewise to highlight the rationale, because for the court, you understand that when the rationale of a doctrine is no longer serves its purpose under contemporary circumstances, that there can be some idea in order to either modify or change the doctrine. You agree?
Yes, Your Honor.
Because the court is not just a computer where we just look at the number of jurisprudence on a particular canonical interpretation, but we are human beings, and that the foundation of the rule of law are two things. One is reasonability, and the other is social justice. You understand? Is that you agree with that?
I agree, Your Honor.
Yes, and I just have two remaining points which I forgot to ask yesterday, and with the indulgence of the Senior Associate Justice, I would like to proceed with these 2 points very briefly in order that we can already proceed. When we say the sovereign people as the entity that we want to protect, and therefore to protect against a chilling effect of a particular vague law or a vague implementing rule or regulation. Therefore, doing an extraordinary facial review. When we mention sovereign people, we are not referring, of course, to something that is concrete. You agree?
Can you please repeat, Your Honor?
When we say sovereign people is a concept. You agree?
Yes, Your Honor.
And in reality, the people, or in Tagalog, ang taong bayan, iba't ibang klase yan. So people, there are very different sectors, very different classes, very different interests in that concept of people. You agree?
Yes, Your Honor.
And when we say chilling effect on people, the court has to be clear, or the petitioners have to be clear and demonstrate which aspect of that concept, people, will be actually affected with the chilling effect. You agree?
Yes, Your Honor.
Without that clear demonstration as to what aspect that is, then we are unable to see whether it is really true that the chill will lead to a stifling of their ability to participate as a sovereign within the political deliberative space. You agree?
Yes, Your Honor.
Because there is certainly a difference between a university professor and a farmer. There is a difference between a person that teaches in the University of the Philippines as compared with someone who just lives along the Chico River, or Dumagat in Quezon, or for that matter, let us say a Maguindanao within the Bangsamoro area, or maybe someone from Tawi-Tawi in Bongao. You agree?
I agree, Your Honor.
So there is an urban-rural difference. You agree?
Yes, Your Honor.
And there is also a rich and poor difference, a difference of class. You agree?
Yes, Your Honor.
For those that are richer, and for those in urban areas, and for those in urban areas, normally they have the resources to many platforms for freedom of expression. You agree?
Yes, Your Honor.
And for those who are poorer in rural areas, or even in urban areas who are really very dirt poor, or who do not have a shelter or who has a shanty for a shelter, their freedom of expression, the modality of their freedom of expression is more limited. You agree?
Yes, Your Honor.
And in terms of the natural courage produced by our political economy, for somebody who is used to making speeches politically, like for example, a professor or a politician, they are used to speaking publicly their grievances, as compared with, let us say, a driver of a jeepney, or for that matter, someone who sells in Philcoa, or for that matter, a higaunon in the mountain plateau of Bukidnon. You agree?
Yes, Your Honor.
Yes. And when we say chilling effect, the fear that pervades somebody that is in the uplands of the Higaonon areas will be much more pronounced than that, for example, of somebody that lives in a subdivision in our urban centers. You agree? In other words, it's more difficult for them to express a grievance. Alam mo, ang Pilipino, alam naman natin, marunong tayo magtiis. Paliwanag lang sa atin kung bakit tayo kailangan magtiis, magtitiis tayo. Sinabi sa atin na kahit mahirap huminga, maglagay tayo ng maskara, ng mask, pinaliwanag sa atin, gagawin natin. Mapagtiis tayong tao. In fact, kapag napaliwanag sa atin, dodoblehin pa natin yung mask. Kahit hindi na halos tayo makahinga. You agree? We are a patient people, yes. But and it's not sometimes our hunger that drives us to shout to high heavens our grievances. Sometimes it is not that. Titiisin pa rin natin yon. But when we see our children and our grandchildren unable to sleep because they are hungry, that is the time that we become desperate. When we see that we cannot line up in Philcoa to get a bag of goods from a community pantry in Maginhawa, in order to be able to feed our children anymore, that is the time that we have the courage to actually express our grievances. And sometimes it is uncouth. Sometimes we copy what we hear from, let us say, NUPL, or what we hear from Bayan Muna. And therefore, it is that time that they have courage. You agree? Is that possible?
Yes, that is a valid observation, Your Honor.
Yes. So for certain kinds, certain people within the entire corpus of citizens, there are individuals that have always been in the minority, that have always been marginalized, that have often considered themselves oppressed. But when they state a grievance, it takes a lot from them to be able to express that. You agree?
Yes, Your Honor.
Yes. And therefore, for them, a vague provision in the law does not translate immediately. It translates through a law enforcement officer that implements it. If the law enforcement officer has a wide option of things that they can do, which can cause fear on these individuals, then the chilling effect on these people is higher than the chilling effect, let us say, for someone that lives down there in Forbes Park. You agree?
Yes, Your Honor.
In other words, Mr. Solgen, perhaps in the memoranda of the respondents, we do not only simply mention chilling effect, but we move forward. You see, this concept of chilling effect comes from our colonial past again, from the United States of America and several other constitutional jurisdictions. But we are a post-colonial world. We are part of the post-colonial world, part of the majority world, but we have an archipelago. We have 192 ethno-linguistic groups. We have classes. We have intersectionalities in terms of our identity. And therefore, perhaps it is now, we should now be very clear that for cases that come up to the Supreme Court, we do not just leave it to the Supreme Court justices to make a judgment. Is there or is there no chilling effect? We have to have some basis, some ground. Is this chilling effect on behalf of those who want to express their grievances but could not because they are poor? Or is this the chilling effect of certain, let us say, academics? Or is this the chilling effect of certain people who just want to get into politics and so on and so forth? You understand what I mean, Soljen?
Yes, Your Honor.
Yes. So, and I am sure that the petitioner is also listening. And I think that it is high time that we understand that our freedom of expression concepts must now be deconstructed, as we did in the case of Diocese of Bacolod versus Comelec. You're familiar with that case, Soljen?
Yes, it's about the tarpaulin, Your Honor.
The tarpaulin. But then there was an expression there of the basis for freedom of expression and the clarity that there can be a hegemony that is present. There can be a culture, there can be a political economy that is present, where some are given a megaphone and others do not. This metaphor of the marketplace of ideas simply does not fit for a world like ours. Because in our marketplace of ideas, some have megaphones, some have generators for their amplifiers, some can only shout to the top of their voices, some, because they are poor, because they are servants, because they are employees, have a hard time to make a statement. And therefore, Mr. Soljen, freedom of expression is traditionally a right that is invoked by those that dissent. You agree?
Yes, Your Honor.
Traditionally, I do not mean only, I just mean traditionally. So in the main, when the Supreme Court looks at freedom of expression, it does not look at the expression of government because you have all the resources in this country. It looks at the expression of somebody that might be minoritized further, that might be marginalized further, that may be oppressed further. You agree?
Yes, Your Honor.
Yes. Now, very quickly, we go to my last point, which is the concept of incitement, advocacy, and proposal. There is definitely a difference between incitement and advocacy. You agree?
Yes, Your Honor.
Yes. Very briefly and as short as possible, what is the difference between incitement and advocacy?
Advocacy, Your Honor, is protected speech while incitement is...
No, that's the consequence. But what is incitement? And how do you know that speech is incitement? And how do you know that advocacy is incitement for the purpose of protection?
In the Philippines, we have applied the clear and present danger test to determine...
I'm sorry, Soljan, I don't agree. That for purposes of incitement, that it is not the clear and... In fact, it is a different rule. Some call it the Brandenburg Rule, which is cited even in the case of Gonzales, where you find the clear and present danger rule. The point there is incitement is a different test from the clear and present danger criteria. But that nonetheless, I will not go into that. I want, perhaps you can clarify the concept of incitement and advocacy. Because if in this particular law, it can be seen that it is vague enough to punish advocacy, and in my mind, just personally in my mind, then you are in trouble. Because then there can be a chilling effect of that person that spends the whole night waiting for 5 o'clock to happen. And when 5 o'clock happens, runs to Philcoa in order to line up, in order to get those goods in the community pantry in Maginhawa. To me, it is very clear. Because then, traffic enforcement officer, a policeman, and as your colleague said, even the military now in Quezon City may be able to enforce this anti-terror law against him or her. Who knows? Unless, of course, the law is very clear and the implementing guidelines are very clear. Before we can do that, you have to be clear what is the difference between incitement and advocacy. Section 4, advocacy. Section 4, qualifier, advocacy. Section 9, incitement. And of course, the aspects of speech in proposal to commit as differentiated from incitement in Section 9. You will cover this in your memoranda, correct, Solicitor General?
We will do that, Your Honor.
Yes. Again, just to end with my opening statement. I personally, and perhaps many of my colleagues will appreciate, not only a catena or list of jurisprudence, but that the Solgen and the petitioners go into the rationale of the existing doctrines that you cite or the existing cases that you cite. If Imbong said this, why did it say this? If Southern Hemisphere say this, why did it say this? And the answer is not only because another case said it, but because what is the rationale there? Because we look at the rationale in the context of contemporary circumstances. Terrorism is happening in a very digital world. Terrorism is happening in such an interconnected world now interrupted by a pandemic. And therefore, we have to see how this particular law can be appreciated at this point. Or is it still opportune for us to wait until there is an actual case? Will there be no damage on the sovereign? And the aspect of the sovereign for which we must be most concerned about in terms of social justice, those that are marginalized and oppressed, will they be damaged as we wait? You will cover that in your memoranda, Solgen?
Yes, Your Honor.
I hope I was clear. Was I clear?
Yes, Your Honor.
Thank you, Mr. Solgen. Again, with apologies, Chief Justice, I am through. I am now yielding to the Senior Associate Justice.
Thank you, Justice Marby. Please proceed, Senior Associate Justice Terry Bernabe.
Thank you, Chief. I call on ASG Calandines.
Good afternoon, Your Honor.
Good afternoon, ASG Galandines. Good afternoon, counsels. In our past sessions, my colleagues have skillfully propounded numerous questions on various key topics in the specific provisions of the Anti-Terrorism Act. Only I and the Chief Justice remain to ask further questions. Initially, I have prepared several questions on the theoretical concepts underlying the ATA's specific provisions. However, considering that most of these have already been touched upon, I deem it fit to instead proceed with a more comprehensive approach of going over the important provisions of the ATA and try to, as much as possible, map out its mechanics in order to clarify, not only for our benefit, but also for the benefit of the public, how the government envisions criminal prosecution under the ATA to practically work. So let us begin with a hypothetical red tagging scenario.
I am very sorry, Your Honor. We were not able to hear. I am very sorry, Your Honor. We were not able to hear what you just said, Your Honor.
Anyway, I was saying that I am proceeding with a more comprehensive approach of going over certain provisions of the ATA, and I will try to, as much as possible, map out its mechanics in order to clarify, not only for our benefit, but also for the general public, how the government envisions criminal prosecution under the ATA to practice work. So I will begin with a hypothetical red tagging scenario. Taking inspiration from Justice Ami's Captain Ree example in one of our previous sessions, let us now consider a fictional character called Colonel Cho for the purpose of this hypothetical. Let us call him Cho for short. Suppose that Cho is a suspected terrorist due to his alleged affiliation with a terrorist organization based on tips coming from anonymous informants. Under the ATA, there are provisions on designation, proscription, and also surveillance. With this scenario in mind, let us discuss the possible actions of the government on the alleged terrorist organization, and later on, we will proceed to determine Cho's individual participation.
Your Honor, Your Honor, again, I am so sorry to interrupt. Your Honor, may we be allowed to fix maybe our audio system? Because really, Your Honor, I cannot, and I only heard about Captain Ree and hypothetical scenario. Kindly allow us It's to fix our audio, Your Honor, please.
All right, all right. But can everybody hear me, or is it my audio that is defective?
We can hear you. We can hear you, Justice Telly, loud and clear.
Yes, so it must be the Solgen's audio.
Nag-testing ba sila?
Yes, we did, Mr. Chief Justice.
Assistant Solicitor General Galandines, can you not use a headphone to make sure that you can hear us?
Mr. Chief Justice, we can hear you loud and clear now, Mr. Chief Justice.
All right, can you hear me now? I'll present again the scenario.
Yes.
Cho is a suspected terrorist due to his alleged affiliation with a terrorist organization based on tips coming from anonymous informants. Under the ATA, there are provisions on designation, proscription, and surveillance. With this scenario in mind, let us discuss the possible actions of the government on the alleged terrorist organization, and later on, we will proceed to determine Cho's individual participation. First is, how will the law enforcement agents determine whether or not the organization of which Cho is allegedly a member is really a terrorist organization? Will the police mainly rely on the United Nations Security Council consolidated list to check if the organization is considered as a terrorist organization? And if so listed, will the government automatically consider this group a terrorist organization without any further verification?
Your Honor, if the organization was designated by the United Nations, we are, as a member of the United Nations, we are mandated to adopt the designation of the UNSC, Your Honor.
So the police officers would just go to the website of the UNSC and check the list right there and there, or is there a more formal process of validation?
Your Honor, it is a presumption that if the group was designated by the UNSC, that it did follow, since it is an international body, that it did adhere to the general accepted principles of due process, Your Honor.
So the police officers will just look at the website. Is that it? There is no other formal process of validating who are in the list, except the ones appearing in the website.
Yes, Your Honor. The UNSC list is periodically updated, Your Honor. And the ATC resolution adopts the consolidated list, Your Honor.
All right. Assume that the group to which Cho allegedly belongs is not found in the UNSC consolidated list. What is the process for designating this group as a terrorist organization?
If it is through domestic designation, Your Honor, the designation must follow the parameters found in the implementing rules, particularly Rule 6.3, Your Honor. That is for purposes.
So you just have a.
Yes, Your Honor.
Right.
6.3 mandates that the ATC would adopt mechanisms to collect and solicit information from relevant government agencies, Your Honor. That would, this is all on the basis of probable cause, Your Honor.
So you have a criteria of designation, right?
Your Honor, I am sorry, we have a criteria of, sorry, Your Honor, I didn't hear the last word, Your Honor. We have a criteria.
You have a criteria of designation is provided in the IRR. Is that correct?
Yes, Your Honor. I'm sorry, Your Honor. Yes, Your Honor. Provided for.
And that is what you will follow. That is what you will follow for domestic designation. Am I right?
That is correct, Your Honor.
Oh, and this criteria applies to designation through requests made by foreign jurisdictions.
For requests under foreign jurisdiction, Your Honor, we also designation pursuant to a request from foreign jurisdictions and supranatural jurisdictions, Your Honor, would have to comply with Rule 6.2 of the IRR, Your Honor. That is again upon finding of probable cause, Your Honor.
Yeah. I can't hear you.
We are sorry, Your Honor. Under Rule 6.2 of the IRR, Your Honor, the ATC may, upon a finding of probable cause, it must be established that the proposed designee should meet all the criteria for designation provided for by the UNSC Reso number 1373, Your Honor. This is a request that would be endorsed by the DFA to the
So for domestic designation,
domestic designation is a third kind, Your Honor. Probable cause from solicitations from relevant government agencies and other sources in order to identify the individual or individuals on the basis of probable cause. For the designation,
so there are three modes of designation, right?
That is
three modes of designation.
Is correct.
Is that correct?
That is correct, Your Honor.
And for designation through request from foreign jurisdictions, you have the criteria for designation of UNSCR number 1373.
Yes, that is correct, Your Honor.
Okay. Now, since the UNSCR appears to be silent on the criteria, can you identify to us and explain the basis of the so-called criteria for designation of UNSCR number 1373?
Your Honor, we agree that
where do you find this? What is the criteria?
We agree, Your Honor, that the criteria is not provided for in the law, but we submit, Your Honor, that that the UN, being an international body, we submit that it espouses and is. We could only conclude that it followed the general principles of law, including due process, Your Honor, and that they would not designate an individual without factual or legal basis, Your Honor.
So is the standard of probable cause in request for designation different from the criteria? Or is it a combination that the government will have to utilize the standard of probable cause that the proposed designee meets the criteria?
Your Honor, we submit that the first kind of designation would differ from the domestic designation, and the second kind of designation, which is a request by the supernatural jurisprudence, Your Honor. Jurisdictions, rather, Your Honor.
So are they separately treated, the criteria and the probable cause?
We submit.
Or it should be a combination.
Your Honor, if the design is already designated by virtue of UNSCR 1373, Your Honor, then it is our responsibility to adopt the same.
Yes, but for domestic designation and for designation through request of foreign jurisdiction, what is going to be the standard that you will use?
For the domestic designation, Your Honor, we follow probable cause, Your Honor, after gathering of all information from different government agencies, Your Honor.
All right. How about the designation pursuant to a request of foreign jurisdiction? You will use the criteria and you will also use probable cause. Is that correct?
Yes, Your Honor, and compliance with if the probable cause and the compliance with the UNSCR 1373, Your Honor.
All right. Can you explain the fundamental differences between designation and prescription, particularly as to their effects?
Your Honor, designation under 25 is different from prescription under 26. The designation would result to the freezing of the assets of the designee, and it's not made it is not dependent on the pendency of any criminal proceeding against the proposed designee, Your Honor. While there is no criminal offense, and this would not result in this would not pave the way to the arrest of the individual who is designated, Your Honor.
About for surveillance, can the government conduct surveillance already when there is designation?
Yes, Your Honor. Surveillance could be undertaken but always with the authority coming from the Court of Appeals, Your Honor.
Bank inquiry, can that be done when one has already been designated?
Your Honor, I am sorry again. Your Honor, I am sorry again. Could you kindly repeat your question?
No, I was asking for the effects of designation and prescription. Now, when you are designated, can the AMLA conduct bank inquiry or bank examination into deposits and investments?
Yes, Your Honor. Upon issuance of the court, is this, or Your Honor? Sorry, your question is about prescription already, Your Honor.
No, designation. I'm asking you the effects of both.
Your Honor, upon designation, the AMLAC can now freeze the assets of the designee, Your Honor.
Yes, you said that already. What else?
The ATC, the law enforcement agency, upon authority of the ATC, also may apply before the Court of Appeals for an authority to surveil the person designated if warranted, Your Honor.
Can there be an arrest when there is designation?
No, Your Honor. Arrest is not one of the consequences of designation, Your Honor. But
all right, go ahead. So what is the difference as to the effects with respect to prescription?
Your Honor, prescription is a judicial process, Your Honor.
No, just the effects. You have freezing. Do you have freezing in prescription?
Yes, Your Honor. There is a freezing also in.
Do you have surveillance in prescription?
Your Honor, the reason why the case is now there is now a case before the courts for prescription. This could already be a result of a surveillance, Your Honor, among others, Your Honor.
So what can you have as an effect when you are prescribed compared to when you are just designated?
When an organization is proscribed, Your Honor, it could pave the way for an arrest, Your Honor. A preliminary order of prescription can result to a preliminary order of prescription could result to the freezing of funds also. So, in the same way as the effect of designation, Your Honor.
So you have the same effects, except that if one is a proscribed organization, you can already effect an arrest because mere membership is already punishable. Is that correct?
That is correct, Your Honor, because that is it already punishable under Section 10 of the ATA of 2020, Your Honor.
Okay. Now, suppose the CHOS organization has already been designated by the ATC as a terrorist group based on probable cause. Will the law enforcement agents still file an application for prescription before the Court of Appeals?
Your Honor, it would depend, Your Honor. As I mentioned earlier, Your Honor, the immediate effect of designation is a freezing of assets of the designee. If this is the lifeblood of the organization, and therefore, if by mere designation they would desist.
So the only purpose why you will have to file an application for prescription is to be able to effect an arrest, because mere membership is already punishable. Because you said you have the same effects other than the arrest of a prescribed member of a prescribed organization.
No, Your Honor. For a prescribed organization, aside from the freezing of assets, since it is already a prescribed organization, then continuous membership in this organization would already constitute a criminal offense, a violation of the ATA, Your Honor, a criminal offense, Your Honor.
That's what I'm saying. When you are merely designated, you cannot effect an arrest. But when you are already a proscribed organization, mere membership is already punishable.
Yes, Your Honor. And a proscribed organization subjects them to targeted financial sanctions, Your Honor.
Yes. Now we go to prescription. I noticed that Section 25 on designation is labeled designation of terrorist individuals, group of persons, organizations, or associations, while Section 26 only reads proscription of terrorist organizations, associations, or group of persons. So going back to our hypothetical, does this mean that it's CHO alone and it's not part of an alleged terrorist group? It can only be designated but not proscribed.
Your Honor, if he commits any of the he
is just an individual. So since Section 26 applies only to proscription of organizations, associations, or groups of persons, then being an individual, he can only be designated.
Yes, Your Honor, because we believe that it would be a waste of government resources if just a single individual will be proscribed. He could as well be prosecuted for violation of any of the sections provided.
What I am saying is that why can an individual be subject to designation but not to prescription?
Because Your Honor, please, if he commits acts in punishable under sections 4 to 12, then he can already be prosecuted. We believe, Your Honor, that prescription would be superfluous, Your Honor. He could already be prosecuted for any of the crimes mentioned in sections 4 to 12 of the ATA, Your Honor.
Okay. Anyway, under Section 26 of ATA, prescription can only be made through an application before a judicial court, particularly the Court of Appeals. Section 26 also states that the application shall be filed with an urgent prayer for the issuance of preliminary prescription order, which may be granted on the basis of probable cause, as stated in Section 27 of the law. On the other hand, designation may be made by the ATC based on its own executive determination of probable cause. So if applied to our hypothetical, what if CHOS group is designated by the ATC as a terrorist group, but later on the Court of Appeals denies the prayer for preliminary prescription order due to lack of probable cause? Will the designation of the group be ipso facto revoked?
Your Honor, may I be allowed to repeat your question? What if the Court of Appeals denies the preliminary order
The prayer for preliminary prescription due to lack of probable cause. On the other hand, the ATC has determined probable cause already. So my question is, will the designation of the group be ipso facto revoked?
Your Honor, under Rule 7.9 of the IRR, if the Court of Appeals finds that there exists no ground for which the application for prescription may be granted, any preliminary order of prescription shall be lifted, and the subject of prescription shall be delisted from the designation made by the ATC. This is the effect of the denial of the Court of Appeals, Your Honor.
So the order of the Court of Appeals supersedes the finding of probable cause by the ATC.
We submit so, Your Honor.
All right. Under Section 27 of the ATA, a preliminary order of prescription may be issued based on probable cause. And the same provision states it shall already be tantamount to a declaration that the respondent is a terrorist and an outlawed organization. This preliminary order can later on be made into a order of prescription which shall be valid for a period of years. Now, if the preliminary order of prescription is based on probable cause, what is the threshold of evidence to determine if the preliminary order should be made permanent? Because I noticed that the law provides a standard for preliminary prescription order but when it comes to making it permanent, the law is silent. What is the standard, the threshold of evidence? Is it going to be clear and convincing, substantial evidence, preponderance of evidence, or proof beyond reasonable doubt?
Your Honor, we submit that since prescription is a special proceeding, the quantum of evidence required is preponderance of evidence, Your Honor.
Preponderance of evidence. That is your opinion.
We submit, Your Honor.
All right. Now, can you briefly explain what law enforcement agents may do to the respondent when on the one hand, a preliminary prescription order is issued, and on the other hand, when the prescription is made permanent? Is there a difference?
Your Honor, Section 27, Section 27 provides that where the court, Section 27 initiates Section 27 provides for the effects of prescription, Your Honor. Within 72 hours from the filing of the application, and if a preliminary order of prescription is issued, the respondent is considered a terrorist or an outlawed organization or association within the meaning of Section 26 of the ATA of 2020, Your Honor. The court.
All right, go ahead.
If there is the preliminary order, if there is a preliminary order of prescription, Your Honor, then the AMLAC can now proceed with the freezing of the assets, Your Honor. It is unlike.
If we apply it to our hypothetical, if only a preliminary order of prescription has been issued against the organization, does this mean that CHO cannot be prosecuted under Section 10 of the ATA? Because the organization is not yet proscribed.
We believe that it has the same effects, Your Honor.
He can already be prosecuted if there is a preliminary order of prescription.
Yes, Your Honor, for violation of...
base it on Section 10.
Yes, Your Honor.
If you base it on Section 10, so what's going to be the basis for the prosecution?
Your Honor, your question was what would be the basis for the prosecution, Your Honor?
No, if only a preliminary order of prescription has been issued against the organization, Does this mean that Cho cannot be prosecuted under Section 10 of the ATA on
Yes.
membership?
Yes, Your Honor. Membership, Your Honor, yes, under Section 10 of ATA, Your Honor.
But what about under Section 10, when one who joins an association or organization for the purpose of engaging in terrorism, would he not fall under that?
Will he not, Your Honor, I am sorry, your question, that will he not fall?
Can you go over Section 10 and see whether or not Cho would fall under any of the circumstances where he can be prosecuted, notwithstanding that a permanent order of proscription has not been issued?
Yes, Your Honor. We submit, Your Honor, that he could be prosecuted because Section 10 is recruitment to and membership in a terrorist organization, Your Honor.
So he can still be prosecuted?
That is our, it is our respectful submission, Your Honor, that yes, he may be prosecuted under Section 10, Your Honor.
All right. Now, what is the difference between a preventive freeze order and a sanction freeze order?
Your Honor, a sanction freeze order is a freeze order as a result of a UNSC designation, Your Honor. The sanction freeze order shall, as provided for in the implementing rules and regulation, this shall remain in force and effect during the period of, sorry, Your Honor, during the period of prescription, Your Honor, of designation.
So when the preventive freeze order is extended, is it converted to a sanction freeze order?
Your Honor, a sanctions freeze order is in compliance with the binding terrorism-related resolutions found in UNSC Reso 1373.
So even if the preventive freeze order is extended, it remains to be a preventive freeze order? It's not converted into a sanction freeze order?
No, Your Honor, because a preventive freeze order shall only be valid. It is our submission, Your Honor, that the preventive freeze order shall only be valid for a total of, for a period not to exceed 6 months, Your Honor. While a sanctions freeze order is in compliance with terrorism-related resolutions, particularly 1973 of Article 41 of the UN Charter, Your Honor.
What is the remedy of the aggrieved party from a preventive freeze order and from a sanction freeze order?
Your Honor, the aggrieved party, during the effectivity of the sanctions freeze, Your Honor, the aggrieved party may within 20 days from the date of issuance, file with the Court of Appeals a petition to determine the basis of the sanctions freeze order, Your Honor.
How about for a preventive freeze order? What is the remedy of the aggrieved party?
Your Honor, we believe that this is the same remedy available to him. During the effectivity of the sanctions freeze order, he may file a case before the Court of Appeals so that the same sanctions freeze could be lifted, Your Honor.
But you would agree that that's not found in your IRR?
Your Honor, we believe that it is found in the IRR, particularly under rule.
Or is the remedy during the time that the extension is being asked?
The sanctions freeze order shall, Your Honor.
So we're done with the sanction freeze order.
Yeah.
You already said that the remedy is really to file within 20 days, the lifting of the sanction freeze order. How about the preventive freeze order? What is the remedy of the aggrieved party?
We submit, Your Honor, that he has the same remedy.
Okay, although not found in the IRR.
We submit, Your Honor.
All right, now, before we leave designation and prescription, can you likewise explain to us the remedies of a person or organization who has been designated, or an organization who has been issued an order of prescription? What are the remedies in case they are designated or they are prescribed?
Your Honor, the question was remedies. Your Honor,
Yes.
Your Honor, the person, the individual designated may file a petition for delisting before the ATC, Your Honor.
All right, so let's now go to the arrest and detention provisions of the ATA. Can a preliminary order of prescription be the basis of an arrest?
We submit that it could be the basis of an arrest, Your Honor.
Why?
Your
Without
Honor,
a judicial warrant, and the offense is not in flagrante delicto.
without a judicial,
By the mere fact that you are issued a preliminary order of prescription does not justify the law enforcement officers from arresting the one charged with the terrorism or whatever.
we submit, Your Honor, that
Or is it necessary that the preliminary order of prescription be made permanent before arrest can be effected?
it is our submission that the order of prescription must be permanent, Your Honor.
Yes, because membership is the one that is punishable. And when you just have a preliminary order of prescription, the law does not say that membership is already punishable. Is that correct?
The preliminary order of prescription, Your Honor, would result to the freezing of the assets of the person who's was a pending
Yes.
case.
I'm talking about arrest. If a preliminary order of prescription has been issued, can that be the basis of an arrest?
It is our submission that it could not be the basis of an arrest because under Section 10, Your Honor, the person must be a member of a proscribed organization, and pending the decision, if the case is still pending before the Court of Appeals, we could not conclusively say that he is indeed a member of a proscribed organization, Your Honor.
All right, let us go back to our hypothetical. Suppose that Cho has been the subject of anonymous tips that he belongs to a designated terrorist organization. Suppose that he encounters a police operatives while he was on his way home. At that moment, he was not doing anything suspicious, although the group to which he allegedly belongs had just been proscribed as a terrorist organization. The question is, can Cho already be arrested and detained for violation of the ATA?
Your Honor, please allow me to understand your question because I think there is really something wrong with our... your question was, if he was...
Okay, suppose that Cho, who, as we have mentioned, has been the subject of anonymous tips.
Yes, Your Honor.
That he belongs to a designated terrorist organization.
Yes, Your Honor.
He encounters police operatives one day while he was on his way home. At that moment, he was not doing anything suspicious, although the group to which he allegedly belongs had just been proscribed as a terrorist organization.
Your Honor.
The question is, can Cho already be arrested and detained?
Your Honor, our position is that if Cho is a member of a designated organization, then it could not lead to an arrest absent any circumstance warranting a that would justify a warrantless arrest under Rule 113. But if Cho is a member of a proscribed organization, then he could be arrested because membership is punishable under Section 10 of the ATA, and therefore he would be committing an offense already, Your Honor.
But if Cho has just been the subject of anonymous tips, can he still be arrested? Puro tip lang, walang personal knowledge.
Your Honor, we reiterate that designation is not criminal in character, and therefore does not carry with it any penalty against the designated individual, and therefore he should not be arrested unless, of course, Your Honor, he did perform acts which would justify warrantless arrest.
So if it is just an anonymous tip, can arrest be effected?
If anonym, well, Your Honor, I could only think of hot pursuits, Your Honor. A law enforcer need not personally witness the commission of the crime. But he also must have personal knowledge. So, if this is no probable cause, Your Honor, needs personal knowledge, Your Honor.
There's no
Be arrested.
Related to this question, when it comes to violation of Section 10 of the ATA, which punishes a person who voluntarily and knowingly joins a terrorist organization, must the police officer, before proceeding with Cho's arrest or detention, first determine whether or not his membership still subsists?
Yes, Your Honor, considering that, if I remember correctly, the words of used by the law is voluntarily and knowingly joining an organization which is knowing fully well
Is
that
continuing membership an indispensable element for Cho's arrest?
yes, Your Honor.
So how do you determine now membership? Is it also through probable cause?
Your Honor, we verify information. The law enforcement agents must verify information that there is continuing membership. This is willful and knowingly joining organization that has been designated as a terrorist group if under 1373 or proscribed under Section 26 of the ATA, Your Honor.
Okay. Let us instead assume that Cho is not suspected to be a member of a terrorist organization, but there are anonymous tips that he is providing material support to terrorists. In order to verify these tips, law enforcement agents then decided to conduct a surveillance of his activities. Particularly, they want to wiretap his conversations through his mobile phone. Can you explain to us what steps the law enforcement agents should take in order to wiretap Cho's mobile phone?
Your Honor, as provided for by Section 16 of the ATA, the law enforcement authority, after being authorized by the ATC, should apply before the Court of Appeals for authority to surveil, Your Honor. Also, since this is through his mobile phone, Your Honor, he must also file an application so that he could compel the mobile phone companies to furnish him with communication with the communication necessary to prove the imputed criminal offense, Your Honor. He must also furnish the NTC with the copy of the application. The NTC must likewise be notified. Rather, the NTC must be notified of this application, Your Honor.
If
Also,
Cho maintains now his innocence and claims that he had only been red tagged, what remedies under the ATA and other rules can Cho avail of in order to protect his right to privacy of communications?
Your Honor, if Your Honor, under the ATA, Your Honor, if Cho could successfully prove that he was just being red tag, again, pardon Your Honor, but we do not wish to use that term. But if he could successfully mount a challenge to this to the authorities, Your Honor, then he may invoke the extraordinary remedy of habeas data, Your Honor.
All right. Now, assuming that after surveillance activities, the police officers found no evidence that Cho was providing material support to terrorists, will his personal records and confidential data acquired during the course of the surveillance be turned over to him?
No, it will be contained in a sealed envelope, and it would be the custody of the Court of Appeals, Your Honor.
Unless it was maliciously procured. Is that correct?
If it was maliciously procured, Your Honor, then the law enforcement agents would also be administratively liable. But the custody of the it will be with the Court of Appeals, Your Honor.
No, because under the ATA and the IRR, it is provided that the information that have been maliciously procured should be made available to the aggrieved party. So it's only then, when there is a malicious procurement, that this data will be given to the aggrieved party. Otherwise, the data go to the court.
Still,
am I correct?
That this is again with the permission of the Court of Appeals, Your Honor.
All right.
With the
now,
appeals, yes, Your Honor.
What if the police officers discovered through wiretap conversations that Cho was not only providing material support, but was one of its top officers who was actually involved in the planning of a terrorist act? Can they immediately proceed to arrest Cho without applying for a judicial warrant? Or does it depend on whether or not the terrorist attack is imminent or not? Can Cho now be arrested?
It is my
Would you consider this in flagrante delicto?
It is my respectful submission, Your Honor, that if Cho is planning to commit an act of terrorism, then the law enforcement agents could immediately arrest him. The element of immediate, but of course, he must comply with the circumstances provided for by under Rule 113. But again, Your Honor, he intends to detonate a bomb, and this was overheard by the police authorities through surveillance. I think there is no reason for the law enforcement agents to wait. They must immediately arrest.
I agree with you. The crime is planning a terrorist act.
Yes, Your Honor.
All right. Now, assuming that the police officers proceeded to arrest Cho without judicial warrant, for how long may he be detained?
Your Honor, our submission is that he could be detained for as long as 24 days, subject to authority provided for by the ATC.
Could
after 36 hours.
Initially, could it be more than 36 hours?
Initially,
which is the maximum period under Article 125.
Our submission, Your Honor, is that without any authority from the ATC, after 36 hours, he must be an information complaint affidavit must already been filed, and in the absence of which, the detainee must be immediately released, Your Honor.
Now, assuming that Cho, at the time of his arrest, was with a comrade who was carrying an unlicensed firearm, the police officers did not, however, have any further information on the affiliation of Cho's comrades at the time. Nevertheless, the police officers proceeded with the arrest of Cho's comrade for illegal possession of firearms. How long may Cho's comrade be detained?
Initially, Your Honor, since he was in a possession of, since he was found in illegal possession of firearms, he could be detained for 36 hours. But, Your Honor, may I just qualify my answer? If the law enforcement agents would be able to secure an authority from the ATC, this comrade could also be detained longer than 36 hours, Your Honor.
Notwithstanding that he is just being prosecuted for illegal possession of firearms? And there is no evidence at all?
Your Honor, but
no further information on his affiliation with an organization or with Cho? I mean, will the authority of the ATC be a license to extend his detention, notwithstanding that he is merely being prosecuted for illegal possession of firearm?
We submit, Your Honor, that the fact that he was in the possession of an illegal, he is in illegal possession of firearms, and he is with Captain Ree, he is with Mr. Cho, then the ATC may the ATC may issue an authority for his continued detention. After all, Your Honor, this may be necessary to prevent the commission of the graver crime of terrorism.
That is very dangerous.
Your Honor, if after 36 hours and it could be determined, if there
anyway, you can expound on that in your memorandum. Now, going back to Cho, since he was arrested without a warrant for an offense under the ATA, will he still be subjected to inquest?
Our submission that he will still be subjected to inquest. Your Honor, the investigation.
Yes, I agree with you. Yes. What if the ATC already authorizes detention for 14 days? What will now be the purpose of the inquest?
Your Honor, his detention without his detention as authorized by the ATC is not synonymous to inquest, Your Honor. So
what is the purpose of an inquest? The purpose of an inquest is to determine the validity of the warrantless arrest and also to determine whether or not he should remain in custody, right?
Yes,
so
sir.
If the ATC has already issued an authority to detain him, that is no longer the subject matter of an inquest. But he may still be subjected to an inquest because the validity of his warrantless arrest, should still be determined. Do you agree? Yes.
Yes, Your Honor.
All right. During his detention, what remedies can Cho avail of?
During his detention, Your Honor, the Cho may avail of the remedy of habeas corpus, Your Honor.
All right. How about writ of amparo?
Yes, Your Honor. He may also avail of the writ of amparo.
How about bail? He can still apply for bail?
Your Honor, bail is only available if there is already, Your Honor, detention, bail after Bail, yes, but if it is already in court, Your Honor.
So under Rule 115, any person in custody who is not yet charged in court may apply for bail.
Yes,
So
Your
these are the remedies. You have
Yeah.
bail, you have habeas corpus, and you have the writ of amparo.
He may also, if he would wish to, he could also question the authority of the ATC to order his continuous detention before the office of the President, Your Honor.
Now, while Cho is detained and the preliminary investigation is ongoing, can the ATC concurrently designate him as a terrorist pursuant to Section 25?
Yes, Your Honor. There is no prohibition, Your Honor.
So is it possible also for prescription proceedings to be concurrently conducted against the organization to which Cho provided material support while the preliminary investigation is pending?
We submit that, yes, Your Honor, prescription proceeding be initiated. Yes, Your Honor.
Now, if designation and prescription are concurrently allowed, will this affect the resolution of the preliminary investigation? What if no probable cause is found in domestic designation or in prescription by the Court of Appeals?
Your Honor, the
This will certainly affect the preliminary investigation. Is that correct?
Yes, may we, Your Honor, may I say, may my answer be a qualified yes, Your Honor, because the designation could result to the freezing of the assets.
No, what I am saying is that if no probable cause is found in the proceedings for domestic designation or in prescription by the Court of Appeals, will this affect the resolution of the preliminary investigation?
We submit that it will not affect the resolution it will not affect the preliminary investigation, Your Honor.
Why? Meron ka nang lack of probable cause before the Court of Appeals. But anyway, you can expound on that.
Also in our
now, Yes. So going back, Cho is suspected of providing material support. During investigation, was further determined that he is also one of the top leaders of a terrorist group, of which he is a current member. It was also found that Cho was one of the main planners of an upcoming mass terrorist attack. If the prosecution determines that there is probable cause for all these claims, will Cho be charged for multiple offenses, namely providing material support under Section 12, membership in a terrorist organization under Section 10, planning the commission of terrorism under Section 6, and even conspiracy to commit terrorism under Section 7?
Your Honor,
all of this, he will be charged with all of these crimes.
Yes, Your Honor, but if ASC Rigodon could better expound on this, Your Honor.
All right, can you please ask him to go to the podium?
Good afternoon, Your Honor.
Yeah, good afternoon, ASG Rigodon. Did you get the question?
Yes, Your Honor. Our position
So what is the answer?
Is that there will be no absorption, Your Honor, and therefore he can be separately prosecuted.
Right. After an information has been filed against him, Cho applies for bail. Since the lower court found that the evidence of guilt is not strong, he is granted, but subject to two restrictions. So he was granted bail subject to house arrest, and second, a prohibition from outside communication. Now, for how long will the restrictions last? Is it for the entire duration of the case,
until the restriction is lifted by the RTC, Your Honor.
So the restrictions can be modified or changed.
Yes, Your Honor.
Correct. That would be all. Thank you very much. Thank you, Chief.
Thank you, Senior Associate Justice Bernabe. It's now my turn to ask a few questions to the Solicitor General. May I request Assistant Solicitor General Marisa Galandines to take the podium?
Good afternoon, Mr. Chief Justice.
Good afternoon, Assistant Solicitor General Marisa Galandines. I would presume that you must have read from the OSG library our primer on oral arguments. Did you read that? Have you read that?
May I admit, Your Honor, that I am sorry, but I haven't read that, Your Honor.
Well, it's kept there by me, Mrs. Dairit. Anyway, the primer tells us that for purposes of oral argument, especially in the Supreme Court, there are three things that you must consider. First, you must be cool. Second, you must be composed. And third, collected. Were you not briefed on that?
We were not briefed on that, Your Honor. But
And that sipping, little sipping of water will help you a lot during the oral argument.
sipping of water.
When you sip a little water from time to time, that will be of great help to you during oral argument.
Thank you, Mr. Chief Justice.
Not only that, I added three other elements on oral argument. They are, you must be alert, you must be attentive, and you must be accurate. Likewise, did you read that article also in the library on brief making prepared by no less than Chief Justice Reynato Puno? Note that two of the amicis are both from the Solicitor General.
I remember, I did read that, Your Honor. It was a requirement by the brief, as to brief making. Yes, Your Honor, because it was a requirement of the...
Although it is titled as brief making, that article also taught us, and you have been hearing from all the the interpellators from the court, that you addressed that in your memorandum, right?
Yes, yes, Mr. Chief.
One of the things that was highlighted in that reading material that we are required to read is that a memorandum filed in court should appear, not only appear, but written in such a way that it is practically a draft of the decision to help the court. Did you encounter that admonition?
I think I remember that, Your Honor, because he had a lecture, he did lecture before here in the OSG, Your Honor.
Okay, so please bear in mind, a number of occasions, my colleagues told you, please address that in your memorandum. Now, I will address you from time to time, perhaps ASG Marisa Galandines or ASG Marisa. Did I tag you?
No, truthfully, truth tagging, Your Honor, yes.
Because ASG was an acronym of a known terrorist group.
That is correct, Your Honor, but I believe you meant assist.
If people will hear you being addressed as an ASG, that does not automatically make you covered by the ATA, correct?
Yes, Your Honor.
Because there should be context and purpose in calling you ASG, right?
Correct, Your Honor.
Okay. Now let's go to the questions. What is the rationale, if you know, based on your reading of the proceedings in the Congress and the Senate, for enacting the Anti-Terrorism Act, or ATA, and totally repealing the Human Security Act?
Your Honor, from the deliberations and from the sponsorship speech of Senator Lacson, I learned that the total repeal of the HSA was imperative because the HSA failed to address terrorism being dynamic, and HSA has failed to address this, Your Honor. Also, there were lack of, um, rather, also because the HSA included predicate crimes, and this made prosecution under the HSA hard, Your Honor. Also, the HSA, the repeal of the HSA was necessary because the HSA did not contain provisions on threat to commit terrorism. Also, it did not include provisions on planning, no provisions on inciting, and despite the fact that we had an HSA, there were no provisions therein that dealt with foreign terrorist fighters. Also, if I remember correctly, Mr. Chief Justice, despite the HSA, we were still included in the gray list, Your Honor, financial gray list, Your Honor.
Are you telling us that one of the reasons why Congress legislated the ATA is that because it is a requirement under our international commitments also?
Yes, Mr. Chief Justice. This was to comply with the Financial Action Task Force recommendation to make the Philippines compliant with its obligations, Your Honor, financial obligations, Your Honor.
Okay. Your main argument in your comment and supplemental comment is that the 37 petitions deserve outright dismissal. And your reason is what?
Among our reasons is that the 37 petitioners have failed to satisfy the requirements for bringing this case before this honorable court, Your Honor.
What specific requirements for purposes of judicial adjudication or adjudicating judicial controversy is lacking?
First, Your Honor, they lack the legal standing. There is no actual case or controversy. There's no actual case or controversy. Locus standi, Your Honor.
What in locus standi are you saying that's missing?
Your Honor, we submit that they do not have a specific interest in this. They do not have a specific interest nor a specific injury which they could present before this honorable court, Your Honor.
So you're saying, as your principal, one of your principal arguments is that, as held in Anak Mindanao versus Executive Secretary, they have not sustained direct injury as a result of the government act that is being challenged. Is that correct?
That is correct, Mr. Chief Justice.
Now, are you familiar with some of the petitions, or if not the 37 petitions filed in this court? Do you have a fingertips information on the allegations?
Yes, Your Honor.
I'll cite to you a number of petitions on the premise of your argument that petitioners lack standing because they are not able to show that they will sustain direct injury. Let's go to the first case of Coordinating Council for People's Development and Governance, GR number 253242. Do you have a copy of the petition? Or a summary of the petition? Or a matrix of the petitions? Or handle reference?
Yes, Your Honor. All the petitions are here, Your Honor.
Okay. Let's go to that first petition I mentioned. The petitioners allege, through sworn statements and reports, that the interagency body National Task Force to End Local Communist Armed Conflict issued an official report containing their photographs, displaying their names and logos of their organizations, and referring to them as communist terrorists or prawns, officials and members of the Communist Party of the Philippines, New People's Army, and the National Democratic Front. Based on personal knowledge and third-person accounts at around the time of the adoption of the ATA, petitioners allege that one of their leaders was summarily executed, that their members and officers were subjected to surveillance and threats of rain, and that during a peaceful protest in August 2020, some of their members were arrested and their publications confiscated. Now, a moment ago we established that CPP-NPA have been designated as terrorist organizations by the ATC. Hence, coupling with said declaration with the allegations of petitioners, is there sufficient basis to establish that petitioners are under credible threat of prosecution under ATA?
We submit that it does not, Your Honor.
Why do you say so, considering not only the allegations, but the incidents that they cited in support of their petition?
Your Honor, it is our submission that these factual circumstances that they narrated are not in any way ATA related, Your Honor.
Say it again, please.
We submit, Mr. Chief Justice, that these factual allegations are not ATA related, Anti-Terror Act related, Your Honor, and that since these are factual in nature, it should be tried by it should be heard before the regional trial court and not before this, and that this not before this honorable court, since this honorable court is not a trier of facts, Your Honor. The circumstances mentioned are factual allegations, Your Honor.
Okay. Let's go to the second petition. Bayan Muna Party List Representatives Carlo Isagani Sarate et
Yes. Yes, Your Honor.
number 252585. To substantiate their claim of legal standing, petitioners attach the official report of the NTF LCAC, where Chapter 6, Annex A and Annex B contain their photographs, their statements and activities, and the names and logos of their party list organizations, and the official report labeled them as communist terrorists. Once more, knowing that the Communist Party of the Philippines has been designated as a terrorist organization by the ATC, is there sufficient basis to conclude that petitioners in the Bayan Muna petition stand a credible threat of prosecution under the provisions of the ATA?
We again, Your Honor, we submit that these are factual allegations which could not be.
Would you consider the citations attached to the petition, the official report of the NTF ETLAC, still a factual allegation?
Your Honor, this alleged threat of prosecution cannot be regarded as an actual case or controversy.
We're talking about their legal standing to file the present petition.
Yes, Your Honor.
Sustain direct injury based on this report, saying that they are communist and terrorist.
Mr. Chief Justice, it is our submission that these are hearsays, Your Honor. And the threat of prosecution would not cure their lack of locus standi, Your Honor.
Will that not affect them personally, this report from the NTF ETLAC?
Again, Your Honor, these are factual circumstances, Your Honor, that should not be elevated before this honorable court, because this honorable court is not a trier of facts, Your Honor.
Okay, let's go to the third petition. Bishop Broderick S. Pabilio versus President Rodrigo R. Duterte et al., GR 252767. Petitioners allege that on December 26, 2019, the Anti-Money Laundering Council, AMLC, caused the freezing of 5 accounts belonging to petitioners RMP, Northern Mindanao Subregion NMR in Cagayan de Oro City, and rural missionaries of the Philippines in Metro Manila for allegedly being used for terrorism financing contrary to RA 10168. The basis of such freeze order are the allegations of the National Security Council that petitioners are part of communist terrorist groups and have been engaged in terrorist financing. Further, National Security Deputy Director General Vicente Agdamag filed a pending complaint with the Philippine Permanent Representative to the United Nations and with other international organizations in Geneva, Switzerland, that petitioners are pawns of communist terrorist organization. Knowing these allegations in mind, do you think that there is sufficient basis to find petitioners in this petition face a credible threat of prosecution under the provision of the ATA?
Mr. Chief Justice, again, we submit that this did not give them locus standi. Freezing, the referred freezing is not under ATA, Your Honor, but it was under 10168, Your Honor. Financing Prevention.
It refers to the Anti-Foreign Terrorism Act. In fact, in the Section 25 on designation, you have been saying that as a consequence of that designation is the freezing of accounts. And you have been arguing that the reason for that designation is simply to freeze the account.
We admit, Your Honor, that we did say that, but again, Your Honor, freezing mentioned by third petitioners is not freezing under the ATA, but freezing under 10168, and therefore did not give.
I'm telling you, Section 25 on designation, and you have been arguing that the only consequence of designation is the freezing of account under 101 of that law, of that Foreign Terrorism Financing Act.
One of the causes is freezing, yes, Your Honor.
Okay. Let's go to the fourth petition. Gabriela Incorporated et al. Versus President Rodrigo Duterte, GR number 768. The petitioners claim that the NTF-LCAC itself filed a verified petition for the cancellation of its registration before the COMELEC on the ground that they are communist terrorist organization. Further, petitioner Gaviera's finances were investigated by the AMLC on the request of NICA. In its initial financial investigation report on Gabriela Incorporated, which is Annex AA1 in their petition, the AMLC concluded that there is a likelihood that the funds in the bank accounts of Gabriela, GAWR, may have been used for or related to terrorism and or terrorism financing. Again, the same question. Don't you think that petitioners have legal standing, that there is a real, direct, credible threat of injury to them under the provisions of the ATA?
Again, we submit, Your Honor, that this did not give them the legal standing, Your Honor.
Since there have been a lot of questions on designation and prescription, I will limit my questions in that area. When a designation is made, it affects the reputation both of the person and the property of the designee. Is that not correct?
We admit, Your Honor.
Okay. If that is the case, is this not covered by Section 1 of Article 3 of the 87 Constitution or the Due Process Clause, that no person shall be deprived of life, liberty, or property without due process of law?
We submit, Your Honor, that the designation provided for by the ATA is an administrative proceeding, is an executive proceeding, Your Honor, that would not require notice to the parties and therefore is not violative of the due process clause of the Constitution, Your Honor.
Are you telling us that an administrative proceeding is not covered by due process clause? That's too elementary in administrative law.
Your Honor,
due process clause applies practically in all proceedings. Civil, criminal, administrative, what have you.
Yes, CIR. Yes, Your Honor. But this is an executive proceeding, Your Honor.
No, but it's even worse. It's an executive proceeding. It would have been different if it was a judicial proceeding. Is na reputation of person not covered by the concept of property in the due process clause? Did you read the case of Worcester versus Ocampo in the 1912 case?
Yes, Your Honor, but I'm sorry, I cannot remember the case but I remember that not for the exact facts of the case, Your Honor.
RA 10168, known as the Terrorism Financing Prevention and Suppression Act of 2012, in Section 11, authorizes the AMLC to issue a freeze order with respect to property or funds of designated terrorist organization, association, group, or any individual. This freeze order is ex parte. In fact, Section 25 of the ATA refers to this provision. Are you aware of any petition or decision of the Supreme Court declaring that provision of Section 11 unconstitutional?
Unconstitutional?
Yes.
No, Your Honor.
Anyway, let's move to another point. Do you have Section 10 of the ATA law with you? You have a copy of the Anti-Terrorism Act?
Yes, Your Honor. Your Honor, may I respectfully give the floor to ASC Rigodon. He is in charge with Article 10, with Section 10, Your Honor.
Go ahead.
Thank you, Your Honor.
Good afternoon, Assistant Solicitor General Rigodon. Aside from you and Assistant Solicitor General Galandines, are there other ASGs available to answer the interpellations of the court? Or just the two of you were designated to?
Based on the manifestation, Your Honor, of the Solicitor General, we are the only ones designated.
Okay. Same question. Did you read that material that we are required to read when you join OSG?
I remember only, Your Honor, about brief making when during my first day, Your Honor.
Yeah, exactly. When you join the OSG, the first day you report is to the library, not to the ASG. For 1 month, you have to read all the materials there, right?
Yes, Your Honor.
And did you read also that material prepared by Chief Justice Puno on brief making?
Yes, Your Honor.
You did?
Yes, Your Honor.
What is bleaching effect?
I'm sorry, Your Honor, can you please...
very useful article, then you should know what's bleaching effect. In fact, you can use that when you write your memorandum, not only the brief. Anyway, let me go to my question. Can you read Section 10 of the ATA? Section 10 penalizes, among others,
the last part, Your Honor. The last paragraph only.
yung penalizes, among others, membership in a terrorist organization.
Yes, Your Honor.
The person who shall voluntarily and knowingly join any organization, association, or group of persons, knowing that such organization, association, or group persons is prescribed under Section 26 of this Act, or designated by the United Nations Security Council as a terrorist organization or organized for the purpose of engaging in terrorism, shall suffer the penalty of imprisonment of 12 years. Okay. What do you mean by membership? Because it says membership in a terrorist organization.
As defined in Section 10, Your Honor, it refers to any person who voluntarily...
So my question is, what is membership? At least from dictionary definition.
Becoming associating with other people, Your Honor, in an organization, Your Honor.
So membership has status, right? The status of being a member. Now, my question is, Rule 113, Section 5 of the Revised Rules of Court provides the specific instances where arrest without warrant is lawful. The first of which is in flagrante delicto arrest. Right?
Yes, Your Honor.
Given that membership in a terrorist organization is a status that one possesses, do you think that an in flagrante delicto arrest is possible for a charge under Section 10? It's a status.
Yes, Your Honor. If the apprehending officer has previous knowledge of that the person to be arrested as voluntarily...
What is the basis of that previous knowledge?
Probably through surveillance, Your Honor.
Through surveillance.
Yes, Your Honor.
Why? Why only through this surveillance and discreet manner?
Because, Your Honor, in the first place, it requires that the person should voluntarily. So the opposite of that is that that individual was not coerced. And
Have you heard of ASG card-bearing members?
Your Honor,
Have you heard of ASG card-bearing members?
I'm not aware, Your Honor.
No, you carry your ID, right?
Yes, Your Honor.
You're an ASG.
I thought you were referring, Your Honor, to...
That's why there's a difference between designation. Nature, context is important.
Yes, Your Honor.
Going back to the question, have you heard or seen an ASG card-bearing member for purposes of flagrante delicto arrest under the Section 10?
Referring to this extremist group, Your Honor.
You said that it could be based on surveillance.
Yes, Your Honor.
What would trigger for law enforcement agents to conduct surveillance?
If through intelligence reports, Your Honor, among others, and if they have assets within that organization who provided them with information regarding the identities and the activities of that organization, Your Honor, that could serve as basis for a surveillance application, Your Honor.
Okay, my question. Though a global phenomenon, terrorism defies universal definition simply because it is constantly shifting in mode. From crashing an airplane into a building to a cyber attack on a health system. Would you say then that given its shifting mode, terrorism must be defined as malleably as possible to meet future contingencies?
I agree, Your Honor.
Okay. Again, I'll go back to my question to Assistant Solicitor General Galandines. What is the rationale for repealing HSA and enacting the ATA?
Your Honor, is the question addressed to me or ASG Galandines?
Answer it if you know the answer.
Yes, Your Honor. Because under the HSA, in order for a person to be held liable for terrorism, it must be established, among others, the existence of the predicate crimes, Your Honor.
Okay.
And so if the act, for example, of if a person is killed, but the killing of that person is not attended by any of the qualifying circumstances that would make the crime of murder, which is one of the predicate crimes,
Okay.
then that person cannot be prosecuted under the HSA.
The petitioners insist that the HSA was a better anti-terrorism legislation because it provided and enumerated predicate offenses which are punishable under the revised penal code. Is that not correct?
That is their contention, Your Honor.
That's their contention. Now, if you will read the HSA, the enumerated predicate offenses, okay, must have happened before a prosecution for commission of terrorism. Is that not correct?
For the predicate crimes, it must at least reach the attempted stage, Your Honor.
Okay. And in the enumeration of the predicate crimes under the HSA, it conflates all kinds of offenses, not even political. Is that not correct?
Yes, Your Honor, it's a mix of offenses, Your Honor.
Mix of offenses that ultimately may result into a complex crime as for purposes of prosecution, right?
Yes, Your Honor, because there was a specific reference to Book 1 of the Revised Penal Code.
So, what about the Anti-Terrorism Act? As presently,
unlike the Human Security Act, the Anti-Terrorism Act did not define the crime of terrorism through predicate crimes, but instead enumerated certain acts that, if committed with intent and purpose, are considered terrorism, Your
and
Honor.
why
Uh,
radical revision made?
yes, Your Honor. Like Your Honor pointed out earlier, it is more malleable because now, if a person is killed, the prosecution doesn't have to establish uh, the presence of attendant circumstances or qualifying circumstances. All
Is,
the prosecution has established is that a person was killed.
is
And then,
it because the present ATA law is preventive rather than curative?
yes, when compared with the HSA, which is reactive, it is more proactive, Your Honor, because it covers preparatory acts, Your Honor.
It
Like,
prevents the happening of
yes,
terroristic acts.
yes, Your Honor.
Existing conventions and protocols do not consider preparatory acts such as training, preparing, facilitating, or conspiring as terroristic acts. Why then UN Security Council resolutions number 1373 and number 2178 urge states to incorporate preparatory acts into the definition of terrorism?
I think, Your Honor, the primary purpose is to prevent terrorism at its inception, Your Honor. Government should not wait for a terrorist act to happen before it can take action, Your Honor.
Would you consider the phenomena of suicide bombings and foreign fighters sufficient reason to expand the definition of the terrorism in 88 to include preparatory acts?
Yes, Your Honor, because the inclusion of preparatory acts allows law enforcers to interdict this type of terrorist, Your Honor.
Okay. Are you aware that in other jurisdictions, such as the United States, the location, membership, and schedule of court designated to issue surveillance authorizations are secret?
I'm sorry, Your Honor, but I'm not aware of that.
Okay. You must read the FISA Act of the United States. Here, meaning the Philippines, under the ATA, the judicial application is public, although secret documents might be subject to special rules on filing and presentation. Is this setup sufficient to provide protection to individual rights?
With respect, Your Honor, to surveillance applications?
Yes.
Your Honor, because if in the surveillance application, the subject of surveillance will be notified.
I'm addressing the issue of
Yes, I'm sorry.
provision in the ATA with respect to proceedings, considering that in other jurisdictions, there is such thing as a secret court. But in the Philippines, under the present ATA, we don't have such thing as secret courts. Would you say that this provision on the ATA provides sufficient protection to individual rights?
Yes, Your Honor.
Okay. In Fonseca versus Ignalaga and Presidential Anti-Dollar Salting Task Force versus Court of Appeals the court defined judicial and quasi-judicial function. Don't you think that ATC is exercising a quasi-judicial function when it makes designation under Section 25, despite the express provision in the ATA law that the ATC is not a quasi-judicial body?
No, Your Honor, because the exercise by the ATC of that power of that function is akin to the exercise by a public prosecutor of his function of determining the presence of probable cause, Your Honor. And in several cases, the Honorable Court said that while such exercise by the public prosecutor may have some features of a judicial proceeding, that is not a quasi-judicial function, Your Honor.
You expound that in your memorandum?
Yes, Your Honor.
In Southern Hemisphere versus Anti-Terrorism Council, we held that designation of terrorists is a judicial function. Is it your position that contrary to Southern Hemisphere, designation is an executive function?
Designation. For purposes of domestic designation, it is it is an administrative function, Your Honor.
Anyway, does the first paragraph, Section 4 of the ATA grant Philippine courts jurisdiction over terroristic acts committed outside of the Philippines?
Yes, Your Honor. Once that person who commits those acts enter Philippine territory.
The acts or the person?
Yes, Your Honor.
Which one, the acts or the person?
Uh,
Because you may commit terroristic acts outside of the Philippines, like you finance the terroristic activities.
Yes, Your Honor, that is punishable under Section 49, Your Honor.
Anyway, in addition to the statement earlier by Justice Marvic Leonen, since you are insisting that the theory of absorption in rebellion is not applicable for terrorism offenses, can you make a clear and precise delineation in your memorandum between advocacy amounting to terrorism under Section 4, proposal to commit terrorism under Section 8, and inciting to commit under Section 9? Please do that.
Yes, Your Honor.
Next question. Under the IRR, the ATC shall adopt a mechanism whereby a government agency or private entity shall recommend an organization for state recognition under Section 12. DSW and CHR have their own system of accrediting civil society organizations, either as a project implementers or beneficiaries or project proponents operating in such conflict areas such as Marawi. Will the ATC accreditation system supplant those of the DSW and CHR respectively?
For purposes of avoiding criminal liability under Section 12, Your Honor, it is advisable that...
We're not talking about criminal liability under Section 12. We're asking about accreditation.
The
State recognition under Section 12.
Section 13.
Providing material support to terrorists, there's a provision there.
Yes, Your Honor.
Oh.
The accreditation of the ATC, Your Honor, is material only if the humanitarian assistance will be given to terrorist organizations, Your Honor. But if it is not, if the humanitarian assistance will not be made to terrorist organizations, the recognition from the ATC is not necessary, Your Honor.
International organizations such as UNICEF, World Food, etc., have partnered local organizations operating in conflict areas. Would this local people's organization be required to undergo state recognition under the ATA?
Yes, Your Honor, to ensure that they will not be held liable for violation of Section 12, Your Honor.
Would it be correct to say that ATA imposes imprisonment even on children involved in terrorism? Remember, it's a common issue now about these minors being involved in terrorist groups. So the question, I will repeat, would it be correct to say that ATA imposes imprisonment even on children involved in terrorism?
I think, Your Honor, there are special laws applicable to children involved in conflict situations, Your Honor.
Yes, RA 9344, but ATA does not expressly repeal RA 9344. Would you say that our courts will not be prevented from applying our rule on juveniles in conflict with law for purposes of determining the form of imprisonment?
The Honorable Court can apply the principle of statutory construction that if the two laws deal with the same subject, it should harmonize first, and if there is inconsistency, or if there is a provision explicitly repealing that particular law, then the later law will be applied. Otherwise, what will come into mind is that
Only apply the doctrine that which is more favorable to the accused should apply.
Or in case of doubt, the doubt should be applied in favor of the accused, Your Honor.
Can you read section 34 of ATA, third and fourth paragraphs?
One, two, three. In cases where evidence of guilt is not strong and the person charged is entitled to bail and is granted the same, the court, upon application by the prosecutor, shall limit the right of travel of the accused to within the municipality or city where he/she resides or where the case is pending in the interest of national security and public safety, consistent with Article 3, Section 6 of the Constitution. The court shall immediately furnish the DOJ and the Bureau of Immigration with a copy of said order. Travel outside of said municipality or city without the authorization of the court shall be deemed a violation of the terms and conditions of his/her bail, which shall be forfeited as provided under the rules of court.
Okay. Have you read the case of Moncupa versus Enrile?
No, Your Honor.
Moncupa versus Enrile simply states that a person is released from detention. Unnecessary restrictions cannot be imposed on him, such as limiting his right to travel. Can you reconcile in your memorandum this provision vis-a-vis the pronouncement of the court in that case of Moncupa versus Enrile?
Yes, Your Honor. We will do that.
Okay. Section 33 incorporates, you have Section 33 with you?
Yes, Your Honor.
Incorporates 9745 into ATA. 9745 is what? Anti-torture?
Anti-Torture Act of 2009, Your Honor.
Yet, Section 4, B4 of RA 9745 considers prolonged interrogation as torture. How can the prolonged pre-charge detention of a terrorist suspect for purposes of investigation be consistent with RA 9745?
Can we expound on that, Your Honor, in our memorandum? Because I haven't read in detail 9745.
Next question. The title of House Bill number 6875 is Amendment of Human Security Act. And yet its contents are complete repeal of HSA. Will this not constitute while this does not constitute log rolling, would it not be deceptive in a sense?
Your Honor, can I refer that question to my colleague?
Good afternoon again, Mr. Chief Justice. We submit that it does not. We submit Your Honor that it does not.
It does not.
It does not, Your Honor.
Is the IRR the government's view on how the ATA is to be interpreted?
Yes, Your Honor.
In your pleadings filed, you mentioned that the President is immune from suit.
That is correct, Your Honor.
Can you expound that on in your memorandum about your argument about this?
We will do so, Your Honor.
Okay, that will be all for the respondents, Counsel. Thank you very much, ASG Galandines.
Thank you very much, Mr. Chief Justice.
The court will now request Secretary Esperon to take the podium. Okay.
Mr. Chief Justice, we are calling General Esperon. Just a minute, Mr. Chief Justice.
Oh, he's not in your office?
He's not in the Padilla Hall, Your Honor. He is in another room, Your Honor. But within OSG, Your Honor.
Okay. You have already 5 buildings. Huh?
Your Honor.
During our time, we were only in one building with 65 lawyers. Now you are more than how many?
30 divisions, Mr. Chief Justice.
That's a lot.
Yes, yes.
And you keep on extending.
No, a lot of cases too, Mr. Chief Justice.
Okay, okay. Anyway, Assistant Solicitor Galandines, may I ask a few questions? I forgot to ask it. Are you familiar with the American history?
I
suppose that one of our requirements in the OSG is that we must do a lot of reading.
Yes, Your Honor.
It's only on law, but other current issues especially. Are you familiar with American history?
I hope I could answer your question, Mr. Chief Justice. I will try.
Sometime in the years 1940 up to early 50s, there was a phenomenon in the United States. Would you know that phenomenon?
If it would refer to the case on hand, Your Honor, I think you are referring to the investigation by Senator McCarthy, Your Honor.
Would you not consider the present situation at that time and now akin as far as our country is concerned?
We respectfully submit that it is not akin to...
What's the term used for that era in the history of the United States?
McCarthyism, Your Honor. McCarthyism. McCarthyism, Your Honor.
Ism.
Yes, Mr. Chief Justice.
You will not agree that that is the situation that we have now in our country?
Again, Mr. Chief Justice, we reiterate that the government is not into red tagging and but truth tagging, and that all actions of our law enforcement agents pursuant to the implementation of the ATA came about after rigorous investigation, case build up, unlike that investigation conducted by Senator McCarthy. The ATA is full of safeguards, Your Honor, to avoid abuses, Your Honor.
Okay, thank you. ASG Galandines.
Thank you, Mr. Chief Justice. General Esperon is already here, Mr. Chief Justice.
Good afternoon, Mr. Secretary.
Mr. Chief Justice, the honorable members of the court, the petitioners, as well as our colleagues in Solgen, and all those who are viewing us in other platforms. Good afternoon to one and all.
Okay. Mr. Secretary, the first justice to ask you question is Justice Rory Carandang. Justice Rory?
Good afternoon to everyone. Good afternoon, General Esperon.
Good afternoon, Madam Justice.
Am I clear to you?
Yes, very clear, Your Honor.
Let's start. This is a follow-up of the question of the Chief Justice to ASG Galandines. Are we not experiencing the same red scale era now?
Perhaps
the McCarthyism?
Perhaps there are similarities in the 1950s. The communists have just invaded Korea, and there were other activities of the communists in other areas. But the similarity ends there. There was indeed a threat from armed communists.
No, that situation now, is it not the situation here in the Philippines now?
Now we have an Anti-Terrorism Act that has so many safeguards, and it is built on it is aimed at protecting ourselves from groups that would inflict upon us violent extremism.
When you say ourselves, people as a general.
We are referring to terrorists, Your Honor.
People, protection to people as a general against the activities of the terrorist.
Yes, Your Honor.
Okay. Mr. National Security Advisor General Esperon, can you explain the evolution of the terrorism in the Philippines right after World War II in the Philippines?
That is indeed quite a long way to go, but I can only say that
in a short, in a short brief discussion.
I would rather start first with the activities of the first terrorist actions. I would go back to 1994 when a group of terrorist veterans from the Afghanistan wars attacked the town of Ipil in Zamboanga del Sur, where they burned commercial establishments, killed several people. That was led by Abdurajak Janjalani.
Okay.
Became the original emir of the Abu Sayyaf group in the Philippines. He was succeeded by his brother, Gaddafi Janjalani, who would later on lead the kidnapping of tourists from Dos Palmas, Palawan, 2001. And at that time, in the year 2000, well, if we remember 2001, September 11, 2001, that was the bombing of the World Trade Center. Indeed, at that time, terrorism of the violent extremist variety had started worldwide. And we know that there had been manifestations or actions of terrorists in the Philippines, including, of course, such things as the bombing of Davao City last September 2016 in a market, night market. Earlier than that, we have seen the bombings of
the Rizal bombing, the December 30 bombing of many years ago.
Yes, and
was that during your time or before your time or after your time? As AFP chief.
2008, I happened to have operated against that group that kidnapped people from Dos Palmas and brought them to Basilan. I was transferred from North Cotabato as brigade commander to be brigade commander again in Basilan. And so when I became chief of staff, I ran after Gaddafi Janjalani. And we got so many of them, but after getting him, some other leaders came up, and up to now there is still an active terrorist group in Sulu and other parts of Mindanao. We of course remember the 2016 attack of Snelon Hapilon, who was the leader of the Abu Sayyaf in Basilan, and they attempted to take over the city of Marawi. That is probably the most memorable terrorist attack that we have had. After that, there were a series of suicide bombing activities. We have had 2 of them in Sulu, and we are still hunting down probable suicide bombers. And so that is the ISIS, or the Islamic State in Syria and Levant variety. But we have another local terrorist group, which we now call the Communist Terrorist Group. They have become, while the Communist Party of the Philippines is indeed a legal organization after the repeal of Republic Act 1700, they continued with their armed rebellion or armed struggle. And that brings in the New People's Army, or the element of violence. And indeed, they have been conducting violent activities, intimidation, and extortions, arsons, and other types that would greatly influence public safety. That, in short, is terrorism in the Philippines, Your Honor.
So from your relating the story to us, it would seem that the general impression is you only have 2 great and 2 important terrorist groups, and I will not, the NPA, and the other one are those extremists who conducted bombing, who exploded. I am not saying from the south, but these are the identified groups. Is that true, Ms. General Esperon? There are only 2 major groups.
Generally, Your Honor, that there are several splinter groups, but just the same, they employ violent extremism.
And these other splinter groups are not yet designated nor proscribed as terrorist groups.
The Abu Sayyaf group has been proscribed by virtue of Human Security Act. But now we are proscribing the CPP in PA, and others have been designated by virtue of the Anti-Terrorism Act.
So
CPP in PA is designated pursuant to United Nations resolutions, as well as their designations by supranationals or other countries, including the United States, the European Union, New Zealand, Australia, and Canada. I'm talking about the CPP in PA, Your Honor.
How about individuals? Are there individuals already designated as terrorists in the Philippines?
I do not want to preempt the Anti-Terrorism Council because I have not seen yet the publication today or tomorrow of the designation of several persons connected with the CPP in PA. But we will do that.
Are you at liberty to name these people, since there have been designations already made?
Well, there have been there is a resolution of the Anti-Terrorism Council, but until we have published this in local papers, we will not name them publicly, Your Honor. Tomorrow they will come out in the papers.
Tomorrow. It's very timely that we are having this questioning of the National Security Advisor. So, since you dated these activities in sometime in 1990s, so when our Constitution was approved in 1987, there is no such thing as terrorism. Wala pa ba noon?
We simply called them insurgents, but as their tactics, techniques have evolved, it's now very clear that they're employing violent extremism, and we all know that they are for the violent overthrow of this democratically elected government and this democratic system of ours in the Philippines. They are doing it through the use of the New People's Army, and this is led by a party with so-called shields, which they term as a National Democratic Front. I can play now, Your Honor, if you would want to know the organizations that are involved. I can play now a video of their number one red tagger.
Number one red tagger. We would appreciate a general if you can show us the video.
Yes, Your Honor, it is only 2.5 minutes of a speech of Jose Maria Sison.
Okay.
Last April 24, 2021, on the occasion of the 47th anniversary of the National Democratic Front. Your Honor, may I be allowed to share my screen?
Sige po, General.
Secretary Esperon.
Yes, Your Honor.
Please proceed with your screen sharing.
Yung kay Joma. Heretofore, nobody has confirmed to us what we have all suspected, that there are underground mass organizations. And now here comes Jose Maria Sison telling us all the names of these organizations, which we know are the ones in open organizations, legal organizations, or have created organizations to support the armed rebellion. I think there's a technical problem, Your Honor, but it's getting on.
OSG, which computer will you use for screen sharing?
Mag-name siya ng organisasyon.
Ano?
Is it the computer of Attorney Hernandez?
Good afternoon.
Yes.
Your Honor, we will be using the computer of ASG Bernard Hernandez, Your Honor.
We will be granting him a co-host account right now. And adding him on Spotlight right now. Oh, sorry.
Yes, thank you. We will have to migrate to the account of the Solicitor General so that we will be able to share the screen.
ASG Hernandez, I cannot put you on Spotlight if your video is not turned on.
We will migrate to the account of the Solicitor General.
Also, this current account po.
Yes, thank you.
Okay.
Thank you.
The account of the Solicitor General is now a co-host. You may start to share screen.
Dear compatriots and friends, my Filipino compatriots and the National Democratic Front of the Philippines and the Friends of the Filipino People in Struggle, or Friends of the NDFP, for inviting me to serve as a keynote speaker in the celebration of the NDFP 48th anniversary celebration. I wish to speak on the important role of the NDFP in the Filipino people's struggle for national liberation and democracy since its founding on April 24, 1973. In the process, I shall cite the NDFP's struggles, sacrifices, and achievements. The NDFP's most important role in the democratic revolution is to arouse, organize, and mobilize the broad masses of Filipino people in their tens of millions and to seek international solidarity, support, and cooperation. For the purpose, it encompasses 18 allied organizations representing all patriotic and progressive classes and sectors of Philippine society belonging to various political tendencies, ethno-linguistic communities, and religious beliefs. The allied organizations include the Communist Party of the Philippines, New People's Army, Revolutionary Council of Trade Unions, Katipunan ng mga Samahang Manggagawa, Pambansang Katipunan ng Magbubukid, Malayang Kilusad ng Bagong Kababaihan, Kabataang Makabayan, Katipunan ng Gurong Makabayan, Makabayang Samahan, Pangkalusugan, Liga ng Agham para sa Bayan, Lupon ng Manananggol para sa Bayan, Artista at Manunulat para sa Sambayanan, Makabayang Kawaning Pilipino, Revolutionary Organization of Overseas Filipinos and their families, Christians for National Liberation, Cordillera People's Democratic Front, Moro Resistance and Liberation Organization, and Revolutionary Organization of Lumad.
Your Honor, it is a 1-hour videotape, but we will stop at that since Mr. Season has already named the affiliate underground organizations of the National Democratic Front, whose primary role is to arouse, organize, and mobilize tens of millions to support their so-called National Democratic Revolution. If I may I again still, in addition to that, present another video of Mr. Season in 1987, where he named the legal organizations that are with them in the National Democratic Revolution, also known as armed struggle or armed rebellion to overthrow government. This is dated 1987.
There are three processes by which the Philippine Revolution is to be advanced. These include the building of the Communist Party of the Philippines, the building of the New People's Army, and the building of the National Democratic Front. The Communist Party of the Philippines was established on December 6, 1968 as the Marxist-Leninist vanguard party of the working class. This party is supposed to be the standard bearer of the working class, which is that class that is the most progressive, productive, and political force in the Philippines.
It is true that a minority class, especially only the party which represents it, cannot win the Philippine Revolution all by itself. At any rate, even while there are the forces of armed revolution, there are the legal democratic forces in the Philippines. The biggest of these is Bagong Alyansang Makabayan, or Bayan in short. It has a membership of more than 2 million members in more than 1,000 member organizations. Its biggest component organizations are Kilusang Mayo Uno, which is the labor center, the Pambansang Kilusang Magbubukid, which is the Kilusang Magbubukid ng Pilipinas, or KMP, Gabriela, the Women's Alliance, League of Filipino Students, Alliance of Concerned Teachers, Cadena, and so on. As I have earlier pointed out, Partido ng Bayan, founded last August 30 and 31, was an outgrowth of Bayan, the big coalition.
That is the short video of a longer version in 1987, Your Honor. And if I may continue with that, what Season was referring to as formation of international solidarity, indeed, there is now the International League of People's Struggles that meets every year, presided over by Jose Maria Season. And their last meeting was in Hong Kong last 2020, and 75 member organizations from the Philippines attended that meeting, including members from the Alliance of Concerned Teachers, Anak Bayan, KMU, Bagong Alyansang Makabayan, Gabriela, and several others. Please open up International League of People's Struggles, and you will see all the names of these organizations from the Philippines, all 70 of them or more. And so, with these presentations, Your Honor, I can only say that if there is such a thing as red tagging, the master red tagger is Jose Maria Season. On our part, we are simply informing the public. This is, of course, what we would call now as truth tagging. Thank you, Your Honor.
Just sorry.
Yes. If you say that is truth tagging, General, and that's not red tagging.
Yes, the red tagger is Jose Maria Season.
And then you follow from that?
For purposes of public information, so that we will not be misled by this movement or triad of the CPP, NPA, NDF that would want to wrest or get for themselves state power through armed rebellion, or what they call armed struggle.
It's what you say.
3 years, and the effects of this armed rebellion has told so much on matters of resources that we have expended on it, and on the sufferings of people in the countryside where they operate.
Can you expound on that, Mr. General Esperon? In fact, I will be asking you on the effects of these activities.
Yes, Honor. Thank you.
on the life of the people, on the spending of the resources of the government to quell this terrorism. Narinig niyo po ako?
May I be clarified on the question, Your Honor?
Ano nga po yung effects, the general effects on the life of the people, the amount of government resources to be able to quell these terroristic activities?
Well, Your Honor, starting with the main force that we use, the armed forces and of the Philippines and the Philippine National Police. For the armed forces, we have now 11 divisions. One division, by the way, the newest division in Sulu is dedicated to going after the Abu Sayyaf. But the 10th division in Davao also goes after them because they have bombed Davao City, and the area of the 6th division, also in Cotabato, covers several areas where the Abu Sayyaf and its and similar organizations operate. In other parts of the country, we have 9 other divisions of the Philippine Army. Most of them are engaged in quelling this armed rebellion by the CPP-NPA. So, on the part of the National Police, they also join us in our operations, especially now in the National Task Force LCAC, because we are with them, the armed forces and the Philippine National Police, together with the local governments, are the main organizations that are clearing the guerrilla bases of the CPP, NPA, NDF. So, I do not know how you would want to calculate the cost of that in terms of operations by government. And the other branch, the other executive, the other departments, of course, have their share in addressing the problems of this insurgency, including, of course, land reform. We have the Department of Agrarian Reform. We have basic services from the SWD, and employment matters from DTI, DOLE, TESDA, and we can even include the Department of Foreign Affairs that goes after their tentacles or their elements that are operating in Europe primarily. And so the cost is tremendous. But the more telling effect would be on the people themselves in the countryside. I have been battalion commander in Agusan. I have worked the conflicted areas in Central Luzon and Cagayan in the 70s, and I have known the effects of this insurgency nationwide. I am not an economist, but I will venture to say that if there is no insurgency in the Philippines, our gross national product would easily go up by at least 1%. But I think the more reasonable estimate would be about 2% minus or taken out from our gross national product. What would be more telling, of course, again, what is telling again is that families are divided into separate organizations. They destroy the basic social unit of the Philippines, the family, because the father, the mother, and the children are organized into separate organizations.
General, was the government effective in the fight against terrorism before the Human Security Act was passed?
May I be clarified again, Your Honor?
Was the government effective in the fight against terrorism before the passage of the Human Security Act?
Well, I have been the Chief of Army Commander and Chief of Staff for 2 years. We had our accomplishments. I must say we were. But did we eradicate insurgency or terrorism. It must not with just downgrading their capabilities. Our campaign must end with totally eradicating these scourges to the nation. In European countries as well as in other nations, it is perfectly all right to be a member of a communist party. But they do not have there a component that is pursuing the armed struggle or armed rebellion. And so, therefore, in Europe, they can always be parts of parliament and even form their groups. But here in the Philippines, they masquerade themselves because they do not want to admit that they are part of a triad that is pursuing armed rebellion and want power for themselves.
General, we had Human Security Act before, and now we have this law, Anti-Terrorism Act. What is the reason why the government shifted from HSA to ATA? Of course, as a national security advisor, alam mo po ang rason.
Indeed, Your Honor, we recommended in the security cluster group that we must come up with a better anti-terrorism act. For the Human Security Act, it was more concerned on protecting the terrorist himself, but not giving your law enforcement and your security forces the right tools to defeat terrorism. For example, if you would arrest a terrorist and later on you would be proven that you have arrested the wrong person, you would be fined 500,000 pesos a day. And so it became a disincentive to our law enforcement officers. Although it was a measure it was a safeguard. But you prevented your law enforcement people from performing their act because you did not tell us where to get the 500,000. Do you get that from the salary of a soldier whose salary is about 25,000 per month? Or from the organization, probably? If you are adjudged to be wrong in picking up one person for 10 days, that's 5 million, Your Honor. Many of our units don't have that kind of operating funds. And so we are glad that the Senate, the chairman of the Committee on Defense, Security, and Peace and Reconciliation, took the cudgels and sponsored and became the principal author of this Anti-Terrorism Act. I'm referring to Senator Panfilo Lacson. He was joined, of course, by the other members of the Senate and later on by the House, which passed this anti-terrorism law, 11479.
Yun lang po ba ang rason?
Oh, well,
the monetary aspect of it?
Not only
that the soldiers will not be able to defray the 500,000 a day fine?
Well, that was enough.
We need to restructure the human security law.
That was
amend it entirely and come up with a new anti-terrorism act.
Well, we also want to come up with a new law because the terrorists have become dynamic. They have changed some of their tactics, techniques, and organizations. We have to address foreign terrorists. We have to address foreign funding. We have to be dynamic also, Your Honor. And we believe that this Anti-Terrorism Act is just appropriate for the times. We had the weakest anti-terrorism law if we refer to the Human Security Act in this region or in the world. This is one reason probably that we are number 10 in the Global Terrorism Index. Number 10.
Wow, number 10.
93 countries. And 60% of that violent terrorist act is contributed by the New People's Army. And so there is one personality from the CPP-NP NDF that claims that this insurgency has no effect in our gross national product. He happens to be coming from the organization called the Ibon Foundation.
Chief, I will yield the floor to you.
Thank you, Justice Rory. Considering that it's already 5:30 in the afternoon, close to evening, the court will adjourn this afternoon session to resume on Monday at the same time. May I request that the Solicitor General, through the Solicitor General, to furnish the court the presentations being presented by Secretary Esperon on Monday, at least in the morning, the video presentations as well as the other presentations that he will use for the next session. Is that possible, Solicitor General Jose Calida?
Yes. I will volunteer to submit now.
Thank you, Secretary Esperon. So to facilitate the proceedings next Monday, please send it to the court first hour of Monday. Okay. Okay. Considering that it's already 5:30 in the afternoon, the court adjourns this afternoon session to resume at 2:30 in the afternoon on Monday, May 18. May 17. Oh, sorry. Medyo malabo yung kalendaryo ng ginagamit natin eh. It's all white. Anyway, my apologies. So, May 17. Okay? Parties are notified of the setting. Parties and counsel are notified of the setting in open court. Please adjourn the session.
Please remain in your respective seats while the Chief Justice and the Associate Justices